respond, to the remarks by the CG. Mr. Chairman, sir.
Okay, thank you very much. The Controller General of the Nigerian Correctional Service, NCOS, senior officials of the Correctional Service, national commissioners, other senior officials of the Commission, the chairman and members of our vibrant INEC press corps, ladies and gentlemen. It gives me a great pleasure to welcome the Controller General of the Nigerian Correctional Service, Sylvester Nwakuche. I think it's not late for the Commission to congratulate you on your appointment, assumption of duty, confirmation, and decoration as the third Controller General of the Nigerian Correctional Service. In the few years that I'm privileged to serve as INEC Chairman, I met all your predecessors as CGs of the Correctional Service, the three of them. So you are welcome to the Commission. The Commission appreciates the long-standing partnership with the Correctional Service in election management in Nigeria. Along with sister agencies, the Nigerian Correctional Service is a member of the Interagency Consultative Committee on Election Security. You have actively participated in all our meetings and deployed your personnel in support of the Nigeria Police Force, being the lead agency in internal security, including elections, during elections, and sometimes during electoral activities as well. I want to reassure you that our partnership in election security will continue to be strengthened. As stated in your remarks, the purpose of your visit today is specifically in respect of voting rights for inmates of correctional facilities who at the moment do not vote during elections and are therefore disenfranchised. We are aware that the right to vote is actually a human right which cannot be taken away from a citizen on account of time being served in a correctional facility. In many parts of the world, including some African countries such as Ghana, Kenya, and South Africa, where our officials observed elections, inmates exercise the right to vote. The Commission is aware of the judgments of the Federal High Court in Benin, delivered on 16 December 2014, and the Court of Appeal, also in Benin, delivered on 7 December 2018, pertaining to the right to vote by 5 plaintiffs awaiting trial. Based on the combined provisions of Article 25 of the International Convention on Civil and Political Rights, 1966, and Section 25 of the Constitution of the Federal Republic of Nigeria, 1999, as amended, on citizenship, the court affirmed the rights of the plaintiffs who were inmates awaiting trial to vote in elections. However, the judges in the 2 judgments ruled that the right to vote is only exercisable when asserted, as it is a choice to be exercised voluntarily by a citizen and not a duty to be imposed by force of authority. You may recall that in recognition of this situation, the Commission had several discussions with the Correctional Service on how inmates who wish to register and vote in elections can do so. When we set up a joint committee involving both INEC and the Correctional Service, we tried to look at all the nitty-gritty issues and technically review what is involved and the way forward. You availed us of data on the locations and types of federal correctional facilities nationwide, you also provided us with statistics on the various categories of inmates, the majority of whom are on remand awaiting trial, who may actually be registered voters. For our part, we raised the issue of access to the correctional facilities for voter registration, creation of polling units, and voter education. On behalf of stakeholders and for transparency, we also brought to your attention concerns about access to our facilities for observers and the media. Political parties also want to know if they will be allowed to campaign in the correctional facilities and appoint polling agents on election day. We believe that working together with you and the stakeholders, we can address these concerns. As we are aware, election is a process governed by law. Again, working together, we can seize the opportunity of the ongoing electoral reform for a clear legal provision that will specifically cover citizens serving time in our correctional facilities. Doing so will clarify the provision of Section 12, subsection 1E of the Electoral Act 2022 on voter registration, a precondition for voting in elections, which is restricted at the moment to Nigerian citizens who are not subject to any legal incapacity to vote under any law, rule, or regulation in force in Nigeria. There are various interpretations as to whether this provision relates to inmates on death row, or those serving life sentence, or those convicted for treason. Our immediate task is to engage the National Assembly for a clear legal provision on inmate voting. Thereafter, we can address the specific issues that may arise in the course of implementation. On this note, the Commission appreciates the role of civil society organizations that have interfaced with both INEC and the Correctional Service in their consistent advocacy for inmate voting in Nigeria. In particular, I would like to recognize Carmelite Prisoners Interest Organization, CAPIO. We worked with CAPIO extensively on this question of inmate voting. We similarly welcome the positive disposition of the Joint Committee of the Senate and House of Representatives on Electoral Matters on issues of inclusivity in our electoral process, including the right of inmates to vote in our elections. I wish to reassure you, the Controller General of the Nigerian Correctional Service, that we are united with you in our shared determination to extend voting rights to inmates of our correctional facilities. A meeting like this goes a long way in reaffirming our resolve in this regard. So I thank you for the visit, and may God bless you.
Thank you.